these operations, production policies getting out. We'll talk today about the commitment. We'll explain the differences between commitment and policy. This is kind of a one-on-one, but like I said in the meeting, we want you to have a working street smart knowledge. We don't want you to become title officers in our class. We want you to be able to talk to a buyer or seller about what title insurance is, why it exists, how to read the report, and how to find things that could be a problem if we don't get them addressed in a timely manner. So that's sort of what the focus of the class is today. There really isn't a PowerPoint. It's got a few handouts if you'd like, but this is just one of those really fun informational classes, as laid back as we can make it. And your questions really matter. There's no silly questions, so be sure to ask. And I'll sit down and be quiet. Michael, take over.
Yeah, by all means, if you have questions when we're done, bring them on. We have, like she said, my name is Michael Cole. I've been at Great American Title since 2017. Prior to that, I was at Lincoln Land Title from 2001 to 2017. So I've been doing this for a little while. Been a title examiner the whole time, abstractor. So I've kind of been on the title side. I have done a few closings, but that was about 15 years ago. I kind of just like the title side of it. So I'm usually in the office, hidden away in a corner. I don't get out much. So it's fun to, interact with some people with title questions. Today, Cindy wanted me to go over commitments. So I just brought some commitments. I didn't bring my laptop or PowerPoint or anything. I apologize for that. So I did bring some copies if you guys want to look at it.
Want me to pass this out?
Yeah, I think there's. I didn't use any real names or any real stuff on here, so but it is a real commitment. It's set up the proper way on how you would see it when we issue it out. Kind of use the Big Bang Theory on this, theme on this one. So. All right, when you enter the contract, when you have the contract and you execute it and you send it to the title company, first thing we're going to do is research the land back at least 45 to 60 years. On residential. On commercial, we're going to take it all the way back to land patent, which is about 1836 in Greene County. And the reason we take it back that far in commercial, there's just more risk, more stuff we have to look at, to be able to insure. But we're going to be talking about residential today. Commercial is a whole nother ball of wax. I can come back for a commercial. So this will be residential focused only today. So, after we do our search for 45 years to 60 years, depending on the circumstance, we're going to be sending a product out like this, and it's called the Commitment for Title Insurance. Basically, once you have that, this is, what you're going to go off. This is what you're going to explain to your clients, this is what, affects your properties, what affects your home. This is what's going to happen. This is what you're going to have to cure or take care of before the real estate transaction is, consummated. So on your first page here, it's going to have some important information. The commitment date is the date the records were searched through. Usually we go to current date, but we backdate it 5 days because there could be some miscommunication with the, public servants with the circuit court and reporter's office. We want to backdate it 5 days just to kind of fill that gap. But our title plans of Great American are caught up to the day.
So what you're saying is we're caught up, but the counties could be behind.
There could be something like, there could have been something not, in the recording bucket. Maybe they misfiled it. Maybe they didn't get it recorded correctly. Maybe there was rejections. We just do that to backdate it. And that's kind of a common practice with all title companies in this market. It's 3 to 5 days. Underneath that, you have your owner's policy. This is your proposed buyer. This is your buyer, Leonard and Penny Hofstetter. That is always going to be where your buyer's location are. B, this is a simultaneous issue, so they're getting a loan to purchase the property, so that's why you'll see a bank name for B. That's usually always going to be your lender. The amounts, $450,000. That's the amount that they're not technically purchasing the property for, but that's the amount they're buying insurance for. So depending on, of course, the contract's going to give us the sales price and all that, but this is the amount of insurance they're wanting to get. If we do not.
Question for you there. So say they're buying the property for 500,000 and they're only borrowing 400,000, can they still get insurance for 500,000?
Correct.
Okay.
Yeah, and even if it appraises for more than 500,000, I mean, as long as we have an appraisal with that amount, we can insure up to that amount. If we're not presented an appraisal, we can go off market value. We can do some comps around the area, and then we can get with our underwriters, and we can, do a base of an
So
insurance.
generally speaking, either the purchase price or the appraisal, whichever is higher.
Correct. And then sometimes the loan amount will be higher than the sales price, and we can still insure the lender and the owners differently, so we can still get proper coverage to both.
You have an extra copy? Sorry.
Yeah, I made some circles on that one, did you?
Several, you have several?
I have the one I emailed you, but that's the last paper copy I have.
Can you, can I make some copies off this
Oh,
real
yeah,
quick?
yeah.
Okay. I think we need 3 or 4 more.
And number 4 on the commitment is going to be your current owner. That's going to be your seller under contract. There are times where we get contracts from realtors where just, you might not know who the seller is. Could just be to be determined or whatnot, but it's our job to find the seller. So that's what that field is going to be. That number 4 is something you all want to, take a look at when you get the commitment, because if that doesn't match the person that signed your contract, that's going to be a red flag. You're gonna be like, all right, well, what happened here? Or if it comes back and it says the estate of, then maybe someone's deceased, then you got some probate proceedings you're gonna go through. But if it just comes through as, Sheldon Cooper's trust, you're pretty good. It's in a trust. We'll be able to convey that out. If it's in a, John Doe or Jane Doe, husband and wife, you'll be able to convey that out. But just look for anything that says estate of or subject to interest of anybody else that's not your seller. Then you're gonna, call that title company and be like, hey, what happened? What's going on? You might have to do some more legwork there on your purchase, get your contract settled. Number 5 is your legal description. And that's gonna be the actual description of your property. That's a made up description, but I know with realty and finance and banks and everyone wants to go to property addresses. That's usually how we determine what the property is, but that legal description is actually how we identify the land. So, and when insurance field, that's all we care about really is the correct legal description. We want to make sure that that is what we're insuring. We're not insuring property addresses, we're insuring legal descriptions. Try to slow down so Cindy can make it back. And that's pretty much the gist of Schedule A. That's going to be your information, your seller, your buyer, your loan, your legal description. Moving on to the second page is Schedule B, Part 1. Those are your requirements. Everything within this page has to be done in order for us to issue the title policy. Usually these are your conveyance documents, like the titles in Sheldon Cooper Trust. So we're going to require a trustee's deed to your buyer. The buyer wants a loan, so we're requiring a deed of trust to the lender so we can insure them, so they can encumber the property and secure the property. After that is, there's a release of deed of trust I have marked on there. Anything else on the requirements, we want to make sure that we get satisfied before the closing happens. Before you get to the closing table, we're going to make sure most of that stuff is done. Especially with releases of mortgage, we want to make sure that mortgages are taken care of. We got payoff amounts, we got everything before you're at the closing table. Now, another thing with this requirement page is another big red flag area. If you see anything there that's out of the ordinary, most of the things you're going to see your warranty deed of trust, release of mortgage. But if you see anything that says release of judgment, release of tax bill, release of tax, anything outside of your normal warranty deed of trust release, there could be an issue.
You want to send a copy?
I always tell all the clients that I speak with, the requirements are probably one of your most important section of the commitment. That's going to tell you where all your defects are as well.
A question for you about that. If there is something that is out of the ordinary, is it the responsibility of the title company to actually point that out? Or is it just going to be in here and if we don't catch it, then it may not be figured out until.
That's a great question. And that all comes down to the customer service aspect of it. What we do what we do is we'll highlight it on the requirements page. Now, if it's something really crazy, we will put an examiner's note. We'll put something in bold underneath the requirement that says examiner's note. This is what happened. This is why we need it done. And then when we email that out to our escrow offices, or if we email it directly to the client, we will put in the email, hey, you need a heads up, requirement number 9 is going to be a doozy. You're going to have to do this, this, and this to get this satisfied. Or maybe you're going to have to track down some errors of law of this person. And usually we'll do background work too. And we'll say, hey, well, this person lives here, this person lives there. Here's addresses. You can help, facilitate the issue.
We like to say that the requirements page is really your conversation with your closer. That's if you were to have a conversation with the closer about this, that's the page. And you may not know what some of these terms are or what the piece of paper is they're talking about, but the closer knows. And so when you review your requirement, highlighting what you don't understand and talking to your closer, excuse me, that's probably how we want you to use this. It's a great tool then.
So when I'm reading through this, it's the requirement page. And so like number 2 says, pay the agreed amount for the estate or interest to be insured. So are you saying that line 2 would say that that has been done, or we're still making sure? I don't understand, like.
2 would be the amounts that are on our invoice to the customer. So they make sure they're paying for their premium and everything so we can issue the policy.
Okay, so then let's look at taxes. So let's say they forgot to pay 2022 taxes.
Okay.
Where does that show up?
That will show up later on down in the requirements. That will show up. We usually kind of list things in seniority on your requirements. So we'll put deeds of trust first. Any open deeds of trust or any
So
open.
it'll actually say this has not been paid, as opposed to the requirement that you're telling me what the description is, but really if this were happening, it would be listed.
Correct, yeah. We
Okay,
would have
got it. Okay.
we have a requirement there that says pay delinquent taxes of 2022, then we would put the amount.
Okay, gotcha.
In
Okay.
fact, he does that. I think he gave you that example. If you turn a couple pages, just a little bit, there's a big question, the little early schedule B part 2, number 8. He's talking about those taxes, and that's what that would appear if you were delinquent.
Okay, so really part 1 is just telling you what needs to do. Part 2 is what we've missed, right?
Well, part 2 is going to show you the amounts owed.
Okay. So, or any failures of part 1.
Yeah, but if you do have delinquent taxes, since we're well past the December 31st cutoff date, we're going to put that amount plus interest on your requirement page. That way you can see the actual full amount.
Oh, okay.
Because the amount on part 2 is just the base tax amount. That's without any dues. And every month without something getting paid, it's going to jump up in price.
Okay.
In Missouri, you have to pay, you have 1 year to pay your taxes. Kansas, you have to split out 2 years. Arkansas is 2, and Missouri's 1. So I deal with the multiple states. So I'm trying to just say Missouri focused.
Sure.
When you say you've got 1 year to pay it, what do you mean by that? Like just the fact that it's due in December?
Yeah, it's due in December, yeah. And then like in Kansas, you have it's split out in 6 months. So you have 6 month due and another 6 month due. So I was just messing with the Kansas file before I came over here, so that's why it's in my brain. That's a great point with the taxes. Also with the requirement, if anything's wrong, if we find any defect in the chain of title, say we didn't find a spouse didn't sign off on a warrant deed 20 years ago or 10 years ago or last year, 6 months ago, we're going to put notes in there. We're going to say, hey, we need a deed from this person because they didn't convey their interest out. If there's a old deed of trust, prior owner, several prior owners, there's multiple ways we can look into that information to get that satisfied without, if the banks haven't, lenders sometimes when it comes to old liens are pain in the butt to deal with. So we have other ways of ascertaining that information and getting it cleared for your buyer or seller. But I just can't point out enough how important the requirements are to read through, just scan through, just see if anything jumps out that, it might take extra time to take care of. 90% of the time, most of these transactions go pretty smooth, but the 10% is to get fun. Okay, Schedule B, Part 2. These are the exceptions to coverage on your policy and your commitment. These are everything that could affect your land, but we are explicitly, reducing coverage out of the policy. We're not going to insure them. And what these are, this is just your tax, and this is gonna show your taxes and the amount due. Number 9, this is the plat information. If your buyer wants to know the dimensions of his property layout, a plat book and page is something you're gonna request for the title company, or if there's a survey book and page, you're gonna request that from the title company. That way you can present that to your clients. They can see the layout of the land and they can see exactly where their property boundaries are. If there's not a plat or survey there listed, then that means there's not one a public record, and there could be one unrecorded. Now, there's a lot of unrecorded surveys in the Southwest Missouri. So that just comes down to asking your client, asking your clients, hey, do you have a survey? Do you have anything? Did your dad have anything? That way we can uncover that, because there's a lot of unrecorded data out there that, once brought to light, we can make sense of it. Number 10 is your covenants and restrictions. Those number 9 and 10 are the most requested items from title company. Those are something we automatically provide. We just send it with our title work because we know we're going to be asked for it. Those are another item that you want to get to your buyer pretty soon, because there could be some codes and conditions in there. It says what they can do, what they can't do with their property. Sometimes it even goes to, the length of your grass, how many trees you can have on your property, how many bushes you can have on your property, if you can have basketball goals, pools, all that. So those are really, really important to read. We've had numerous clients, ask us and then come back after that. Well, we didn't know that we couldn't put a swimming pool there. Well, it was on page 12 of your restrictions. And that's why we list it there, because we're showing it to you. This is for your information. But we cannot be sued because, we can't put it there because we told you about it on this restrictions. That's why it's very imperative, anything on these exception pages, get a copy of, go over with, read it, go over with your clients. Everything else on this, number 11 is an electric line easement. So that says there's electric line easement to short circuit. That shows that you have electric line servicing your property. Number 12, the water well agreement. The reason I included water well agreements, because those are something that's usually asked for by realtors to us. Hey, is there any water well agreements or any roadway agreements? Is there any agreement whatsoever? Those are very imperative to take a look at, because there could be provisions in there or assessments in there for your proposed buyer who might have to make monthly payments, might have to make yearly payments to keep that well agreement or keep that well updated service and whatnot. And there could be provisions in there too, where the people have to access part of your property to get to that well and service it if something happens to it and they have to repair the motor or anything like that.
So Mike, if the buyer wants to see where some of these easements are, what are their recourse? Is there?
Ask your title company. Most of the time, what we can do, we can provide a drawing of your land and we can plot out those easements on that drawing, and then we can provide that to you. If you want to know the exact location, like to the precise location, you're going to have a surveyor come out and they will plot those out for you.
We can take legal descriptions of those easements and
Correct.
kind of plot that out a little bit. Okay.
Yeah, we're more than happy to draw out any legal description and easements, and we can plot them out on a paper where you can visually see them and you can show those to your client.
Is there a charge for that?
It's just part of our service.
Wow. That's awesome.
I've got a question about these. So I have one that's in a subdivision and all of the easements are just kind of generic for the subdivision. Is there a way to tell just from the title commitment whether they are more specific than that and we need to look at the actual plot or get a survey?
That is a great question. The common theme when someone is doing a new subdivision is when they're doing like a master for that subdivision, they're going to do the whole sub at once when they're searching it. So they're going to put any easement that just affects maybe the northwest corner of the subdivision. It may not affect all the lots, but it affects that subdivision. So initially it's going to be put on the commitment, and it might affect lot 1, but you might be doing lot 23, but it's still on your commitment for lot 23. It's just a standard, kind of a normal thing for title companies do. They don't specify, what lot it actually affects. Some do, some don't. But, with that, I would call the title company and say, hey, do these easements, show me where they are. Do they actually affect this lot? Are they lot specific? What we'll do in our commitment is on parentheses after the easement, we'll put lot specific. That way, it only affects certain lots and not every single thing. But there's a lot of common, especially like with river cut. You might look at a river cut commitment and you see like 5 pages of easements. You're like, there's no way all these easements can affect. But, you know, some of them tie into each other, especially sanitary sewer easements. You'll see commitments littered with those, especially on new subdivisions. And underground electric's a lot of big deal too. Yeah, any easements, agreements, fence lines, you know, encroachments. Encroachments is another big thing. Those are going to be listed on your exceptions page. I didn't include a chain of title, but your 24-month chain of title will also be included on your exceptions page. Any really wild note, like if there's something that hasn't been taken care of, it'll be noted on your requirements and your exception page. Because if it's not taken care of on your requirements, we're going to take exception to it on the exceptions page. Those are really reserved for the really special problems like lack of access. You know, lack of access means you don't have vehicular access to your property. Just because you can walk to it doesn't mean you have legal access. We want to verify that you actually have legal access to your property. You can get to it by car, and that's through a public thoroughway. You know, if it's a private drive, we have to make sure that there's an easement granted to your buyer for that private drive. You know, access is a big deal. It's one of the biggest claims out there.
We get that question a lot about private roads. Does that come up a lot in your business where you don't know if it's a county road or if it's a private road or just a long driveway, or seems we get that question a lot.
It comes up, yeah, pretty much if you have a, if it's, you know, Bird Drive or Bird Lane, if it's a drive or a lane, it's probably private. And there could be dues or assessments to do with that. So there could be multiple people going in for the gravel or the maintenance of that road.
Or there could be unfortunately nothing. Your lender wants something.
Yeah, but it's our job as a title company to make sure you have access to your property. Those are just one of the many things we look at when we're reviewing the property. But that's one of the important is access to your property. The old law in Missouri law for access, common access, was if a goat could access it, you had access. That's not the case anymore. Now you have to have actually vehicular and pedestrian access to your property for us to be able to insure it.
Let's say you have to get a use easement or whatever it's called to gain access to the property. How long does that take usually?
Depends if the neighbors are willing to play ball or not. And if you have to access, you know, a road that goes over their property, it just depends. It can be really, really quick and easy, or it can be a long drawn out process where maybe you have to take that person to court. Maybe it's a deal where the road's been going over a person's land for 80 years. And then that person got mad at the person who bought this neighboring property. And they're like, well, I'm just going to close it off. And we've had that happen. And then we'll defend it, you know, if they've been using it for that long, because that's called a prescribed easement. And so we'll go to court, you know, our underwriters will defend access on that. And then that might just take some time to battle it out in court, but you know, our people will defend the buyer in that case. But sometimes depending on how it's done, you know, it could take days, it could take weeks, it could take a year.
I'm in the middle of that right now. And we're gonna like quit claim the chunk of land that we're gonna have to go over to access. But what about like a well? Let's say it's the same thing, but it's a well. So somebody has illegally put a well on somebody else's land and they catch it. Is it an easement for like their hardship of not having water or something like that?
Yeah, I mean, you can go back into that prescribed easement per se, you know, it's been in use and it's been used for that property. You can't take it away. You know, it depends on when that well was placed. If there's any unrecorded agreements out there that someone could present to us, if there's any, you know, any type of recorded agreements we can look at. Sometimes they throw these things on the warranty deeds. You might see a schedule, say Schedule A or see Exhibit A on a warranty deed. You go to look at that page and you're like, oh, well, there's a whole bunch of restrictions there. And you might have to look at it that way to see, you know, where the well is or whatnot. You know, my advice to that is, you know, if you're on a rural land, you know, if you're in a situation where you might have thousands of dollars in attorney fees to fight that, you know, might even be, you know, if you do not have insurance yet, you know, it could be something you could just dig your own well. You know, the clients could just dig their own well rather than paying thousands in attorney fees to rectify the situation. But it also depends on the situation. But as a title company, we're going to point that out on the commitment. If if this person if there's any defects in a well agreement or roadway easement.
You also talked about, I think it was on, not requirements, but exceptions for number 5, liens or right to lien that are not shown in the public record. So that'd be an exception to the policy, meaning there's no claim. How much, do you have any, like, does this come up? Do you,
Mr. These, number 1 through 7 are what you call the standard exceptions. These are the most often requested to be removed from title policies. Now, we can remove these if requested, but that's after our seller and buyer execute the owner's affidavit and survey's affidavit. After that's executed at the closing table, and if they request these to be removed, we can. The reason why they're on there is because we can only search and we can only ascertain what's a public record. We can't go into people's houses and look for everything. So unless it's recorded a public record, that's the only way we can find it.
we want to know about it?
And so that's what a lot of these are, rights or claims of possession, not by public records, easement or claims, not by public records. This is just, and number 4 is a big one. That's what, if you want that removed, you know, you have to sign our survey affidavit, but number 4 is a big one. Because that could cover any defects shown by a survey that's on the public record. That's why I was, you know, pointing back to the beginning of the conversation when I was talking about, you know, ask your buyer, ask your seller if they're in rural areas, if they do have a survey, if they were planning on buying a survey, especially if it's meets and bounds, you know.
So we could record that and then one of these paragraphs might be able to remove it.
Correct.
Okay, that's what you're saying. Okay.
You know, she brought up a good point with the easements. You know, if you have a subdivision, you have like 25 different easements on there and you want to make sure that, hey, you want to see those on your lot, ask us. And, you know, ask the title company, have them perform that duty. That way you can, you know, and if you see one that doesn't affect, then ask them to remove that from the commitment. That's definitely a, you know, common courtesy thing that the title company will accommodate. Then I just like to, there's so much we can go over with this. I just want to kind of open it up to questions.
If someone purchased property, owns it in their own personal name, has title insurance, and then decides down the road to transfer ownership of that to like a trust that they've created, does that title insurance still enforce or does it die with?
If they're doing it to their own trust, it will convey over to their trust. You know, if they deed it to like a different corporation or an LLC where other members involved, then it won't. But if they're, say they want to deed it to an LLC, or they're the sole proprietors of, or they're the sole members of, no one else can have it, that can be extended to that as well. But it has to be those same people.
So in a circumstance where someone was to do it to an LLC with other members or something else, what options do they have at that point? Can they go back to the title company and renew that title insurance?
They can purchase another owner's policy, and what we can do, since we did the repeat business, and most title companies will do this as well, they'll do what's called a reissue credit, and they'll give them a break on the premium. That way they can, you know, make sure that, you know, they have owner's insurance, and plus the amount might go up too. The appraisal might be going up in that time, and you might want to up the insurance as well. But that's what I would recommend. If you're going to bring someone else on the title, then that's going to kind of nullify your owner's policy. So go ahead and maybe repurchase another one, and that way you can have both owners, you know, taken care of and insured.
So does that also apply, like if there's a single person that purchased the house and they get married and they decide to put their spouse on the deed to the house, then that also kills the title insurance?
It doesn't necessarily kill it, but it, you know, we won't be insuring tenants by entirety. So once you're single and when you're married to a husband and wife, then that becomes a unity, you know, it becomes almost like an entity. You know, husband and wife is, in Missouri looks at a tenancy by entirety. So you're looked at as a whole. When you're just single people, one person owns 50%, one person owns 50%. So technically, if like you bought it and then you got married later, you know, you would own it at 1/2 interest as a single person, you know, and then she would have half interest marital rights. Technically, she don't own the property, but she would have marital rights to the property.
That's without making any changes.
Yeah.
But if they wanted to go like do a quick claim or something and change the vesting, then their title policy is not matching their new vesting. Is that right? Okay.
Yeah, that's what we're insuring on the owner's policy is that particular person. But like if you do bring someone in title, I suggest, repurchasing your owner's policy.
What kind of coverage would they have if they didn't repurchase it? Because, we all know 99% of the time, someone's not gonna do that. So what coverage would they have?
No,
if
you're
they didn't?
gonna be covered 100% up until, the date of that policy. So anything after that date of the policy, you won't be covered.
Date of the policy, what do you mean by that?
No, the date of the policy is like today, or say it was yesterday, so you'll be covered, everything that's up till July 24th. And prior, you'll be covered, so anything that
Anything
happens
that's
after,
uncovered.
yeah, so anything happens after, then it wouldn't be covered.
Title insurance protects the future from the past. So or I guess the past from the future, really. You're protecting what did happen and you're insuring to make sure that it's a clean record by the time it transfers. But then any damage that the new owners do, that's on them until they sell again. And then we clean that ownership up and make sure that's all conveying, without any liens or anything like that, that's all clean. So it kind of ensures the future from the past, if you think of it like that. So the date that you close, that's what your insurance is to. You don't have continuing insurance. Did I say that right? Yeah. So that's, got to think of it like that. So when we talk about policy date, this is the commitment to that policy, and policy date goes into effect at closing. So this is our working copy until we get to our closing. Does that make sense? And so all these things are issues that we're dealing with right now, and the day we close, all that's going to be wiped out, handled, corrected.
Well, you brought up a good point too, like say John Doe purchases property, later marries Jane Doe, but never puts Jane Doe in title. Well, when John Doe dies, well, his property will automatically transfer to her since she wasn't on title, even though they're married and they got married after the fact. They will have to go through probate to handle his estate. And that's why, we tell proposed buyers, if you're married, if you are going to take title by yourself, maybe, contact your local attorney first, but if not, maybe consider filing a beneficiary deed or something along those lines. That way, if someone does die, you don't have to handle the property through the probate estate.
So I've never heard of a beneficiary deed. Explain more about that. Is it kind of like on an automobile where you're putting transfer on death?
Same thing. Yeah, so I filed, because I'm a single person, I filed a beneficiary deed right after I bought the property to my kids. So if something happens to me, nothing will have to be administered through probate. They'll automatically get the property. There won't be anything they'll have to deal with.
And that's a document that a title company can help you with?
Yes. Yeah, we can help prepare those. We can help file those and make it a part of your transaction.
So you're saying that someone can do that at the time that they're purchasing the property as part of that process, but someone could also come back and do it later on after.
Oh, yeah. You can do it anytime you're the owner of the property. You can file one anytime. And if, say you didn't like the first beneficiary deed you filed, you don't have to file a revocation or release for those anymore. Just the filing of a new one will revoke the old one.
Okay. So that's a really good idea. I'm gonna have to start suggesting that to my clients.
Yeah.
They do that. Why is that not more commonplace? Like on an automobile, when you go to register, they specifically ask you, you don't have a transfer on death. Do you want to put one on here?
Yeah, it's a great point. It's something, that you can definitely, when you're out there in the field to your prospective buyers, bring that point up, especially for people that want to take title. Maybe one person's credit's not as good as the other person's credit, and they only want one person on title. Well, they can be put on title, they can do the loan, all that, then maybe after everything's recorded, and maybe you can throw them on title via quick claim deed or warranty deed, or then file a beneficiary deed. That way, if something does happen to you, your property's protected and it's going to convey to the person you want it to convey to.
So that brings up a good point. So say it is that situation where there's two people that are going to live there, but because of credit issues, one of them buys it. If they, as part of the process, have a beneficiary deed, does the lender throw any fit about that?
No,
Because it's not going to go into effect until the
yeah,
person
because it won't
dies.
go into effect until that person's dead. So yeah, the lender, they have no say in what you can file as far as beneficiary deeds or anything like that.
And is there an additional cost at the time of purchase if someone wants to do a beneficiary deed?
Yeah, there'll just be an additional deed prep cost. I mean, depending on, what's all involved and with it, it could just be an extra recording fee, or it could be an extra, just an extra title service fee on top of.
Like pretty minimal
Yeah, minimal.
charge.
Yeah.
What about if someone wanted to come and do it after they've already taken possession of the property?
Yeah, and, we can do that as well. We call those, we do a title search report, we call those like courtesy, closings or whatever. We do those from time to time, where someone comes in and like, hey, we just did our property closing with you, now I want to do a beneficiary deed to my kids, and we'll do that.
And we're talking about like a few $100s or something.
Yeah, usually, I mean, I don't want to, misquote anything, but, usually around $350 or less, I would say. Yeah. Attorney, is gonna probably charge their hours plus, recording fees and all that other stuff too. So, and then we have in-house attorneys and stuff, so we can kind of, save the cost in that.
One other question, back to the title insurance and transfer of ownership. What if a husband and wife purchase the property and then they get divorced and then they do a quit claim deed, so that one spouse is off of the deed now? Does that affect the title insurance at all, or does that remaining spouse still have full coverage that was originally
It
purchased?
depends if they purchase the title as husband and wife, on that property. If the owner's policy is in both their name, and then one of them got divorced and then they quit claim their interest out, then that person's interest would be covered by that owner's policy. But I would suggest, possibly repurchasing one. That way you can get it solely in your name and get that person off.
Thank you.
And just to kind of clear up things.
Can you do that when a spouse dies? Or should you do that when a spouse dies?
When a spouse dies and they're on title,
Yeah.
that's a great question. Husband and wife, if you own property, a husband and wife, and your spouse dies, that his interest automatically transfers to you. That's called the tenancy by entirety rights in Missouri. So, I mean, technically, the bank might want, maybe a new lender might want you to do a quick claim deed or warranty deed, from, Jane Doe, surviving spouse of, and then quick claim deed to Jane Doe.
I just had because I had that happen, I just sent the death certificate.
I was just gonna ask, would a
That's
death
all you have to
certificate, 2
And
minutes?
it's
to
it's
clear all
switched
that
over
up?
and they just take his
Yeah.
name off.
Yeah, and when we'll do, if we have any inclination that someone's passed away, maybe, once we find out, maybe a husband and wife did take title and they signed the, but only one person signed a contract. Well, that's gonna give us a clue. Maybe someone died, maybe got a divorce. And so then we have to open it up more than just the county that the property's in. Usually we're just searching like Greene County. If the property's in Greene County, we're just gonna search Greene County records. But if there's a death or probate or anything like that, we have to open it up statewide. That way we can make sure we're not missing anything. We don't want to miss a probate or miss a death recital or death certificate filed or anything like that. And we also will search obituaries, things like that. But, what we usually do is require a death certificate for our files, but we're not going to record that. We're not going to make that a public record. It's just going to be for our files. And then we'll probably throw a recital on the warranty deed that states, Jane Doe, died so-and-so date, was married to John Doe, never having been divorced. Now, if Jane Doe, John Doe's on title and the divorce happens, the divorce will sever that husband and wife. It won't remove them from title unless that attorney is very, very well in the know and knows how to write those divorce decrees well to where the property is actually divested in the degree. 9 times out of 10, that never happens. And you have to do a quick claim deed after the fact.
But they usually do the quick claim deeds. My experience is that
Most of the
that
time
gets
they do,
forgotten. So
but-
here they do them.
Yeah, most of the time they do, or the court will order one, but it just depends on what the court orders or anything like that.
So if 2 people, let's say he bought the house and we're not married and I move in with him and we live together for 10 years, we have kids, we do all of that as if we're married. But then he dies. If I didn't do something to that title work, I'm out. It would go to maybe the kids or.
Yeah, since
other
you're not on
heirs.
title, then that would be revert to the heirs at law. By operational law, when you die, it goes to your heirs at law. And unless there's a probate administration open in one of the circuit courts.
Okay, so if that's my situation, I've got to get him to an attorney or somewhere and get a quick claim deed so that I can come back. I can be.
Yeah, I would never drag your feet, if your client's going through divorce or anything like that, never, ever let them drag their feet and, getting those quick claim deeds, because gosh, sometimes we can't get those done, or sometimes the spouse is very angry and will not have anything to do with signing. And then we have to get the attorneys involved because there's a rule the judge can, enact and make, someone sign for them, but that's like last resort case. It's like, we don't really want to go that avenue unless we have to, but, you see a divorce, we'll make sure we get those deeds pretty quick because someone could just skip town, you never see them again.
You're saying that when someone's getting a divorce, make sure that the attorney gets a quit claim deed right then as part of the proceeding? Is that what you're suggesting?
Yeah, if your clients are, in the middle of a divorce, make sure that they're, getting their property settlement agreement, make sure that that's actually being looked at through a fine tooth comb. Because just in my experience in the last 25 years, divorce attorneys aren't the best with real estate.
So let's go back to our unmarried couple. Let's keep them unmarried. So our unmarried couple, and only one of them can apply for the loan. The other person doesn't qualify. Will the lender allow both people to be in title
That's a great question.
without being both of them on the deed of trust?
In Missouri, everybody signs something. That's something you should remember when you're dealing with a
Write that
loan.
down.
In Missouri, we're a marital rights state. If you sign a loan agreement without the signature of your spouse, it is deemed fraud of marital rights.
But if they're not spouses,
And if they're not
But if they're
spouses,
not spouses, then, they don't have to sign.
but the lender will still allow them to be on title if they want to be, and they should be if they're buying a house together,
Now,
right?
one thing too, if say your co-borrower is not on title,
Mhm.
the lender may want, them to do the loan, but we have to have the person that's on title sign their consent for that mortgage. But even if their credit's bad, we might have to do
And they
that.
can still be a vested owner on title.
Correct.
So you guys, I come from a state where the lender can say whether or not that other party, the non-borrowing party, can be on title. And a lot of times they want the deed of trust to match your deed.
Right.
So if you're not allowed on the deed of trust, you're not allowed on title, and you have to quit claim and all that afterwards. And this is blowing my mind that every state can be so different. So be careful if you're practicing in Arkansas or Kansas, because all these laws can be really different.
Missouri, Kansas is way different.
Yeah.
Big differences there. between-
I'm like, whoa, I'm taking notes, I'm learning here.
Yeah, yeah, and we deal with, people that buy property in multiple states, so it's like we have to
Yeah.
remind them, hey, this is Missouri law.
Sit down a minute.
But yeah, the spousal deal, the marital rights is a big thing. If you are married and your spouse can't execute the loan because their credit or whatnot, there is an instrument that we can, provide. It's called a assent to waiver of marital interest. They sign that, and that's since they're, that consents to their spouse doing the loan, and it waives their interest, marital right interest, and allows one spouse to sign the deed of trust. But they have to sign the affidavit. That's why I revert back to saying everybody signs something. Because if not, everyone signed the deed of trust, then one of the non-borrowing spouse has to sign the affidavit, the waiver affidavit.
Okay, and I gotta hear claim stories. You don't get out of here without a good claim story. Do we have anything, or you're hearing in the industry, it doesn't have to be with us, but just stuff that's going on that,
Yeah, I go to the lake a lot, so I'm at Timber Rock Lake a lot, and there was I can't tell the people's name.
no.
but There's a very, very popular, almost celebrity type person down there bought some property, and down there on the lake, you can only own property above the government fee take line, which is 930 feet above sea level down Timber Rock. Well, they thought that they were just gonna, landscape all the Army Corps of Engineers land in front of their property and cut down trees so they could see the lake really nice and easy. And, they made it almost look like a tropical little sand area down there, and you can't do that. And so, yeah, they, there was, things were filed, obviously the Corps, won that suit because you can't do that. There was things on the title work that stated, you can't, we're not gonna cover that. You can't build, you can't do anything below that take line. And so, yeah, there's some pending litigation going on.
it's not resolved.
No.
What do you think the cost of that's gonna be by the time it's done? Is it gonna creep up into the millions? Sounds like it could.
I mean, I've been down there and seen it in person, and I can tell you that the beach and everything's been removed. All the little trees and stuff that bushes were planted have all been removed. So they're in the process of cleaning it all up. So, I mean, they tried to beautify their property. It's neat, it looked really cool, but you can't do that on core land, unless you apply for a vegetation permit. And even if you get that vegetation permit, they're gonna give you limitations, conditions on what you can actually plant, take down or do there. But I will say, if you're buying lake property, pay attention to where your boundary lines are and don't cut down trees.
Well, that's something that a real estate agent should make sure and inform someone that's buying lake property to make sure they can understand.
The core is brutal.
The core is brutal
And they don't give.
and the Department of the Forestry, the Agriculture, the Forest Department, they're like mortal enemies too. So it's like.
Table Rock's worse than Lake of the Ozarks.
Yeah, Lake of the Ozarks is a whole different world because there's no Army Corps of Engineer up there. You can build right on the water.
Table Rock is.
Table Rock is one of the core lakes, Taneycomo's not a core lake, it's owned by Empire District Electric. Lake of the Ozarks owned by Ameren. So those are two different lakes. They're kind of like no holds bars up there. But there's still, take lines up at Lake of the Ozarks. I think it's 660 feet up there. But still the rules and it's not regulated near as much as Table Rock. It's kind of a good thing. I mean, Table Rock's a lot.
Got a question. I'm new here. What's a quitclaim deed?
Quitclaim deed is just it's like, I'm gonna quitclaim any interest I have in this lot to you. It's something that, it will convey your interest, but it's not rock solid. It's not like you're not warranting and defending that like a warranty deed. So a warranty deed is really what we do when we convey the property, because the seller is granting, warranting, and defending, hey, this is the actual property, this is the real description, I'm conveying everything I have to you. A quitclaim deed is kind of, it does it, but not near as good. And it's something, if it doesn't have that warrant clause in there, a title company is not really going to want to insure that property without doing some more due diligence, because then we're going to know, well, why is the seller not wanting to warrant defend the property? What do they know that we do not? That's kind of a red flag. If someone's only wanting to sign a quitclaim deed, it's kind of a red flag. Unless it's like a wife or an ex-spouse trying to remove their interest. Those are the most acceptable ways to do quitclaim deeds, is just removing a spouse.
What can I do as an agent to help a client with a quitclaim deed?
Get them in touch with the title company, that way they can do, if they have an attorney under retainership, have them contact their attorney first. And then their attorney can contact a title company, get the ball rolling. Usually an attorney's gonna want to title search of the property. That way they can see what's going on before they advise their client on, when and where to sign a quitclaim deed.
It'd be a great idea if you're trying to solve a problem and you guys want to use a quitclaim deed to call someone like Mike first and just say, here's our idea. And he can throw up all those red flags for you. Well, this is what we look at. You may create a situation where you have an uninsurable property by the time you're done, or you have a cloud on it, right? And so Mike could sit there and look at the situation, look at the property and say, hey, this is what's going to happen if we do this, or if we do it this way. Maybe there's another way of doing it that won't cloud title. It's always better, just like an attorney, it's better and cheaper to call your professionals first than after. Always, it's always cheaper just to call, and say, this is our idea, this is what our issue is, and this is our idea. Maybe we've seen that issue before, and we can just tell you, well, this is how we fixed it in the past. So it's always good to come consult with people like Mike, who are not an attorney. They're sensitive to the timeline, right? We're all under pressure under time, and won't cost you what an attorney would cost for that consultation. And he can tell you, well, if you do this, here's where our clouds are going to be, or this is the perfect solution for this. Great idea. So I don't know, that's what I do. If I was having an argument with my neighbor, or we're trying to fix something, or there was a road that we couldn't identify, or we do identify it as private. We've got that one guy back there who's not going to allow this. What are our options? And getting some advice first before you go see an attorney, and make sure you get a good real estate attorney. We would know who those people are too. So it's just a good idea to call a title company a lot of times.
I'd say ask questions and read everything.
Yeah.
That's something that was always told to me. There's no such thing as a dumb question, and make sure you read everything. That was something that was just pounding in my head. Read every line, even if you've read it 1,000 times. Read it again.
Yeah, because people do, they just, we'll just quit claim it, and they go down to the county and they record them, and then now we've got something completely uninsurable. to the title company, they're like, yeah, approve this.
Well, and we
because-
scour contracts too. So if you put notes in your contract, if you put something under the special agreements, you put something anywhere on that contract, like I was taught to read those things front to back. So I mean, if you know of something ahead of time, put it in your contract, put it in your email to the title company. That way you can kind of give them a head start on maybe a potential claim or potential problem that they can go ahead and try to resolve. Because most title companies are going to try to resolve that rather than trying to send you off to an attorney or someone else. They're probably going to try to get that done for you. You know, rather than send you somewhere else.
So like if client A wanted to quit claim to client B, can they do it at a cost?
And if it's part of the transaction in hand, now if it's just separate off the table, there's gonna be more fees involved with that. But if it's just something like, we have a lot of the time where like John Doe, Jane Doe own the property in their trust. The lender doesn't want to loan to their trust. So what they'll do is they'll deed back into the individual names, do the deed of trust. Then after we file the deed of trust, we'll do a quick claim deed back into their trust name. We do that afterwards. So there's a lot of transactions we do that way just because there are some particular local lenders that do not want to loan to trust, even though if their trust has the provisions in there where they can borrow money, some banks won't do it. They want to do that in their individuals. And a trust is looked at as a legal entity. It's not, the trustees are not entitled to the trust. It's the actual trust. You almost look at them as like a business per se. Trustees are not entitled in Missouri. In other states they are, but in Missouri, the trustees are not entitled. It's the trust.
Wow.
Can you put your info on the board? Like, can we call you if we have questions like this?
Yeah. I mean, feel free to reach out. I mean, I can leave some cards here. I can also shoot an email out, that way you guys can have my information. And, feel free to reach out, not only to me, reach out to whoever you guys normally deal with, reach out to the title company. That way they can help. 'Cause that's what we're doing. We're searching all the background. We're looking at all the stuff that, through a fine tooth comb, and we're to make sure it's clean title. Like I said earlier, we go back, 45 years at least. That's Missouri standard. We're checking signatures on every page. We're making sure everyone's signing off. We're making sure every easement's signed off by the right person. We're making sure every old mortgage has a release filed for it. We're making sure right people are executing it. We're even making sure people aren't forging names. So there's so much stuff we're looking at for every instrument that we look at. And,
How do you make sure someone's not forging the name
well,
past document?
Well, what we do is we'll get multiple documents that they've signed, like say John Doe and Jane Doe had 10 deeds of trust. We might look at all 10, we might look at the signature lines of all 10, or just maybe in our head, hey, the signature may be very different there. It's very hard to find forgery, but we have come across a couple instances in the last 5 years where we've sent it up the chain to state council and state Department of Insurance, and they've confirmed that it was forgery. But when in doubt, throw a question flag up, throw a red flag up. So, but, we have a lot of clients where they might be up in age, where they might be in a nursing facility or something like that. We really got to check signatures there, because if it just, looks really sketchy like that, we're going to have to throw a red flag up there, or maybe require an affidavit to be executed by the witnesses that this person was in sound mind when they executed the document. There's different, different things we can file after the fact if we need to, but signatures are one thing we're always looking at, especially, the fraud has picked up so big in the last several years with cyber attacks and all this different things. I mean, signatures and online notaries and all that stuff, we're really looking at more than we ever did. Because there's a lot of people trying to, and power of attorneys, a lot of people doing false power of attorneys, just filing a power of attorney, and they might even know the principle of the power of attorney, but they're just going to do it that way. They can try to sell their property and get proceeds.
Yeah.
So there's a big claim. It's not our company or anything like that. It's just a national, news later, we get, and there's a deal down in Florida where there's people down there that just filed this false power of attorney, and they're going around selling people's summer homes, condos. So they come down out of the summer, we're just doing the whole summer down the condo, and it's been sold.
That's a rude awakening.
Yeah. There's a vacant land, same thing, where people are doing that with vacant land.
Yeah, people see these
Scam.
vacation homes and these fraudsters, they're trying to think of everything they can. They're like, well, no, I am this person, because they're only there X amount of months of the year. So, I mean, the neighbors really might not even have met them. I don't even know who they look like. And there's some very sketchy stuff going on in the vacation home places. And so we have to look at that Lake of the Ozarks, because that's a huge vacation home area. 90% of the people that, that's just their vacation home. They don't live there. And We have to check those documents with a fine tooth comb.
Vacant homes in California, that was a big one, 5 or 6 years ago. It was just, it sat vacant. It was the same type of fraud. They pretended to be the owner and it was a legitimate sale. You know, they hired a listing agent. They had the selling agent. They had a legitimate buyer with a loan and just sold the house underneath the real seller. So yeah, that's a painful issue.
Yeah, and it's,
Yeah, those are
unfortunately,
big
the cyber
claims.
attacks and the frauds, that's probably the most claims we see now is forgery.
I think the
cyber-
Midwest is kind of protected, you know, the coasts, we see a lot of this on the coasts, but I think it, you know, it comes.
We see it out there first, then we learn from what they're doing,
Yeah.
and then we stop it before it gets here.
Payoff fraud is a big one for title companies where the seller's loan, we contact that lending company and they send us a payoff. A lot of times, not a lot of times, but sometimes that payoff is fraudulent. And when we pay off the loan at the end of the transaction, we're sending it to the fraudster unbeknownst to us. So that's a big one. And so that's an internal issue of ours. We don't really involve you guys in that, but a lot of our teams, they have to do their due diligence and make sure our escrow staff has to make sure that that payoff is legitimate. And we have third-party companies that help us. We have our own examiners that help us and just making sure that it's the right company.
Yeah, like one of the documents we look at and when we're doing our search and our chain of title is, release a deed of trust or deed of release or reconveyance. So that's when you're releasing the mortgage, you're releasing the deed of trust that secured that property. We have to look at those at a fine tooth comb because those can be fraudulently done and they are fraudulently done a lot. There could be a seller out there being like, well, I'm just going to create my own deed of release and file it in a recorder and, I'm going to sign the vice president bank's name. We got to look at
Yeah.
that stuff.
And that's not really nefarious. They're not trying to steal anything. They're just trying to complete the paperwork process. But still, those are.
Yeah, I
those are
mean,
issues.
fraudulent releases happen, when that happens and, obviously the bank's gonna know when they're not getting payments and they're gonna start filing, the paperwork to do foreclosures. And that's when the title company's gonna be like, okay, something happened, let's get the attorneys involved. So,
One thing I really appreciate about Great American, having come from another area and working for other companies, we'll track those releases, legitimate releases, as they don't always, like the underlying lender doesn't always get that release back to the public record in a timely manner. So we'll track it for a year. Mike was telling me, we'll look every month for that release to be recorded, so that we're keeping the record clean. And if it's not there, then what happens when it sells again in five years down the road and you didn't get a release 2 loans ago? That's a cloud on title. And some title companies will, what we call paper over it or insure around it, just kind of ignore it. But it's a really big deal. So with Great American taking that time to find those releases and get them posted and make sure that they're recorded, it's not only keeping our plant clean, it's keeping the public record clean. And I just really loved knowing that we're making that effort because not all title companies do, especially when you get in our smaller counties around the area. There could be a lot of slop there. So it's kind of good to know that we're
some
taking
of the smaller
pains.
counties, they are still using fax machine and
Yeah.
they still take, lunch hour breaks for the whole office leaves and then you gotta wait to come back. But,
Yeah.
I, learned the older way and the newer way of searching. So it's like I've had to do the courthouse runs and I've done it digitally. So it's like I know both
So you
ways
know
and how to
both
do it.
ways.
But yeah, releases are another big thing that we look at. We want to make sure they're executed by the right person at the bank.
Yeah. Otherwise, we could be in a fraudulent situation and not know it. And
Or
then,
the new buyer could end up, losing their property via foreclosure because the prior seller wasn't, did not inform them. But, if they sign their owner's affidavit at closing saying, hey, they knew of no liens or no outstanding deal, then, they can be sued for those losses.
Is that something title insurance would cover if
Yes.
that happened?
Yeah, if they sign the owner's affidavit and all that, yeah. And all title companies are gonna have, some form of owner's affidavit signed at closing.
the reason they sign those is so we can go back to that seller and,
Yeah.
So you said.
yeah,
Yeah.
so pay up because we just had to pay your buyer, so.
Yeah,
So
those are
the
standard
buyer's
forms.
protected.
All title companies will do
Yeah.
those. So it's kind of their protection.
I got one more question. How do you guys search for and find easements?
We have a title plan. What we do is, anything that's recorded in the recorder of deeds, no matter what county, we have title plans all over the state in Missouri, Kansas, and Arkansas. Anytime there's a recording done, it's, I'm just speaking for Great American. That data is sent to us. And then we have a data team that puts it geographically index it into a title plan. That way we can geographically search any property and we can pull up a list of everything that affects that specific property. So when running the easement, we can just search, say, we want to know what's all on lot 42 of this subdivision. When we go to our title plan, type in lot 42 of the subdivision, we're going to get a readout, a history printout of everything that happened on that lot. And that's why it's imperative to do business with a title company that has a title plan. I'm not telling you who to choose, but choose people that have title plans, because if, you're at a risk if the person's not using a title plan.
Who has the biggest title plan in town?
I'd say they're all pretty equal. There are some, I can't really say who probably has, the most records. Since I worked at two of them. And I know other people that work at, next door and on Bradford Parkway there. I'd say there are there's only a couple title companies in town that have records all the way back to patent. I'll say that.
All the way back to what?
There's probably 2 or 3 title companies in town that have records back to 1836.
Statehood.
Everyone else probably does most of their searching down at the courthouse. But very few have records that go back that far. I can say that there is a title company in town. When the courthouse caught fire in the 1930s, they went to that title company for backup so they could redo their records.
Really old time company.
So beneficiary deed. If someone executes a beneficiary deed today, and then 6 months from now or somewhere down the line, they create a will that conflicts with what was recorded in the beneficiary deed, how does that play out?
The beneficiary deed, since it's recorded first, will take precedence unless that will is filed with probate court. If that will has been amended to probate court, then depends on how contradictive it is. But if one person has left it in the beneficiary deed and there's a separate people who's left it in the will, those people are I can't speak for them, but they're probably going to be an argument. They're probably going to end up fighting for it, and they might have to file, and challenge that will in court.
So a judge would determine
But a
that.
beneficiary deed filed to bypass that situation. It's so they don't have to deal with anything in the probate court. That's why beneficiary deeds were created.
So what would the best practice be there if someone had filed a beneficiary deed and then decided down the line that they wanted to change something and they were working with a attorney, a trust attorney or whatever to create a will, and what would the best practice be to go back and update and create a new beneficiary deed?
Yes, and basically, see what that attorney is gonna, offer in that regards, if they're gonna revoke that beneficiary deed or they're gonna file a new one that coincides with that will. But I would say if you have any future changes, that you want to change your beneficiary deed, make sure that you either do a new beneficiary deed or revoke that one, especially if you're gonna go the will route. But I will say this, if you go the will route, you're opening up, to probate court. You're gonna have to deal with their scheduling and deal with their timelines.
So the better way of doing that is truly the beneficiary deed.
Yeah, because it's just wham bam, as soon as the last grantor is deceased on that beneficiary deed, property automatically transfers to the beneficiaries. And that's without anything extra recording. Now, I've seen this one time in 25 years where we've had a beneficiary deed done and it was to like 3 kids, 3 different brothers. Well, one of the brothers didn't want anything to do with it. So he filed a disclaimer of interest. Now, a beneficiary has 30 days after that beneficiary deed is filed to file that disclaimer of interest. After the death of the last grantor, sorry, apologize for that. He has 30 days after the death of the last grantor of the beneficiary to file a disclaimer of interest saying he doesn't want anything to do with that property. And then it would go to the other 2 brothers per se.
So also, I'm sorry to dig so deep into
no
this, I'm
worries.
just curious, but so I know when you're doing deeds and then say your situation there where it's left to the husband and wife are gonna leave it to their 3 children. Is there something that specifies that if when the 2 parents pass away, one of the children is now deceased, does it go to the remaining 2 children, or does that child that passed away, their share go on to their heirs?
That's a really good question. Most beneficiary deeds are gonna have the wording PS on there, linear descendants per Starpy, and that just means it is gonna pass on to the next linear descendant, so the next of kin would get it rather than their heirs. If it doesn't say the LDPS on there, then it's gonna do like what you said, revert to their heirs and their heirs and their heirs, and so long down. When you're dealing with heirs, you can really get down a rabbit hole and be down in that rabbit hole for a long time.
But is that something that's brought up? Say I've got a client and they're buying a house and we want them, or they decided they want to execute a beneficiary deed. Is that talked about? The fact that if they don't change it, that, you know, Johnny passes away, then Johnny's share is gonna go to the remaining two kids and not Johnny's kids? Because I almost think that most people would logically think that it's the opposite of what you just said.
Yeah.
That if Johnny's gone, then Johnny's two children are gonna get Johnny's share.
Yeah.
So is that brought up?
That's normally, like 9 times out of 10, that's how it happens, because the attorneys around here know to put that language in there. But, you know, there are circumstances where maybe it's out of state attorney preparing that beneficiary deed, and they might leave that out, and then it could, you know, fall by the wayside. But I would just say, like earlier, ask questions, ask, especially when you're, buying property or selling property, especially buying property and you have kids, or you have a potential, you want to leave it to someone, ask those questions to the title company or, your in-house attorney or personal attorney.
So if I was helping a client and I talked to them about a beneficiary deed and they say, yeah, that sounds like a great idea. Okay, and you're wanting to leave it to these two people. And then, so I could just ask them at that point, okay, if one of those two people is deceased, when you pass away, do you want the whole share to go to the remaining person, or do you want it to go on down to those heirs?
Yeah.
And then we could just relay that information to the title company who could prepare it accordingly based on what their wishes are.
Yeah, and by all means, in your email or in your special agreements, in your contract, wherever you want to put it, as long as we get it in some kind of correspondence where we see it, we're gonna know to explore that avenue and get it done for you. Yeah, we can help with those. We can help facilitate, water well agreements, private road agreements, we can help, get those done as well.
So private road agreement, how important is it to have that? So like I live down a private road, it's a 1/4 mile long, it's a paved road. It was initially to be built out to a, 10 or 12 house subdivision. There's only 3 houses that are all at the end of that private road, and we have no private road agreement. It's like, what are the downsides of not having a private road agreement? And
the downsides would be, who's gonna pay to re-gravel or, maintain that road? Who's gonna pay for damages to that road? Who's gonna do snow removal, anything like that? Who's gonna be paying for all that? And who's gonna be splitting those costs? If you don't have an agreement, then no one can put those costs on you. No one can, say you owe this or you owe that if there's no agreement out there. So yeah, I would say with 3 people involved, you guys could come into agreement and say, hey, how are we gonna split these costs if this happens? How are we gonna split this cost if this happens? And that's usually what's inside of a road agreement. Usually just pertains to maintenance, if they have to redo it, and snow removal. Those are the biggest items when it comes to private road agreements.
And how does it work because in our case, there's the 3 houses that were actually built, and then there's one person that owns all the other land that was never built. So how does that work if three out of the 4 entities that own land within that subdivision agree, but one person doesn't? How does that work? It just doesn't happen then, or?
We would have to, that's a great question, because that 4th person that might own it all to begin with, he might own that land that private road is on, unless your property description goes to the middle of the road. Without seeing your description and drawing it out, I couldn't tell you if it goes to the middle of the road or not. It might just go to the edge of that road. You might not own any part of that private road. You might have it just an easement to use it or whatnot. But if
in this case, the person that owns the other land was not the person who originally developed the.
Okay, yeah. In a situation like that, I would just have to look at the chain of title and kind of see how the property was split up and kind of see who had it last when it came to that road. And then, that's information we look up in our search as well. If we are asked to do an easement, like say, we might have to search the neighboring land or the adjacent parcels. There might be 10 parcels that use that road. We might have to search all 10, get the current owners. That way you can reach out to them, talk to them about their agreement. We also might need to see if there's a deed of trust on any of that property that affects that road, because if that deed of trust could be foreclosed on later down the road, it could wipe out your guys' private road agreement per se. But that's.
Sounds like a really sticky situation.
I'm telling you, private roads are an issue. They really are.
Yeah, access is it's a big deal, you
Yeah.
know, there's a lot of stuff that we're looking at behind the scenes to make sure that, you know, the customers are happy and they're not gonna 5 years down the road go out, you know, try to come back home and there's a gate blocking the house or something like that, which, you know, in my experience, I've heard of that happening. We've had clients call in, my neighbor Bill just threw up a fence, I can't get around it. And we've had some people actually put concrete, you know, blocks, cement, and actually do a whole thing, you know, I guess their neighbor was gone for a week or two and came back and, you know, there was actually a structure there blocking. But yeah, I would say, you know, get along with your neighbors. When you're the buyer, you know, reach out, see, you know, tell them you're gonna be buying this property and, you know, reach out to them and see, you know, if they have any issue with anything like that.
That's actually probably a great practice for a buyer to go talk to the neighbors and say, hey, I'm buying this property. Is there any issues that you know about?
Yeah,
That the seller may not be telling.
I recommend it. That's what I did when I bought my house. I went and talked to the neighbors beside me and behind me and across the street. And I just, and it was my dad that gave me the idea. I didn't ever even thought of it. And I'm like, you know, I'm gonna do that. And then, so now I just kind of recommend that to any prospective buyer, any of my friends that want to buy a property, I always tell them, hey, just go talk to the neighbors, kind of get a feel, see how they are.
Yeah.
Because, you know, you want to get in good with at least one or two of your neighbors. That way they can look after your property when you're gone or on vacation or whatnot. So,
Well, I'm gonna look a little closer at drives and lanes.
yeah, if you got a driver lane, there's more than likely it's private.
Yeah, okay, yeah, because lenders, a lot of times new lenders will want a road maintenance agreement anyway.
Especially secondary market. Secondary market lenders are definitely going to want to protect themselves with the private road agreements, anything like that. They want to make sure that that road is being maintained because heaven forbid if they have to foreclose on that owner, they don't want to, you know, wipe out their access because if they don't have access, then they got to go to court and, you know.
They can't foreclose if they don't have access. So
Yeah. Yeah, a deed of trust is really, you know, that you get into a whole other realm in there when we're checking into deed of trust and the validity of the legal description.
Whole different group of attorneys.
But on that private road agreement, do all the parties have to agree for it to take
All the
effect?
parties that use that road, correct, would need to come into an agreement.
Yeah. And if one won't agree, then it just isn't gonna happen.
Might not. It depends too. I mean, if that other person, if they are using that road, but maybe they access their property via another farm road, maybe they abut, you know, another road that comes up and they can get in their access that way, then maybe, you know, they can be cut out of using that. But that could all be done, you know, with attorneys and, you know, the neighbors, you come into those agreements, but you know, any rural area, I mean, you know, meets and bounds is, you know, your description that's not a subdivision. So if you're like lot 10 or lot 20 of subdivision, that's called a subdivision. If you're, you know, commencing at the northwest corner, section 21, township 23, range 21, that's a meets and bounds description. So, you know, ask for well agreements, ask for road agreements, make sure it has access, ask the title company, hey, we have access, you know. But also, you know, when you get your commitment, go to the exception page, make sure they're not taking exception to like lack of access. That should be like right underneath the taxes, first thing. Because if your property doesn't have access, it's landlocked. That's a problem. That's a markability problem. And I think it's marketable itself if it doesn't have access. Those are major things that we're checking out too.
Well, I've learned a lot today. I thought I knew a lot about title insurance, but I learned.
Well, there's just so much. It's hard to
State specific
state
stuff.
specific because there's so many different scenarios that come up. I mean, I could fill a room, you know, like this, just different scenarios. And that's why I always, you know, encourage, ask questions, because the more unique situations you can come up with, I can try to answer those the best way possible because, you know, there's just so many different situations I've encountered over the last 25 years that, you know, sometimes I forget about them until someone brings it up. I'm like, oh, I dealt with that 10 years ago. I know how to fix that.
So I just gave you my card. So you're out in the field and you've got a question, something happens, call me and, you know, Mike's right behind me. He's on my speed dial, so I can get him that way too. Call him directly if you like.
Yeah, my email
He's busy,
address, I don't have my
busy
card on me, but if you guys want to jot this down, my email address is mcole, it's MCOLE, and that's GAT ozarks.com. And yeah, feel free to reach out with anything, any questions, any possible, you know, problems or anything like that.
Cole at GAT.
GAT ozarks.com. And my number there is 823-0800.
417. 417?
Yeah, 417-823-0800.
Thanks for being here. Did you learn something that you didn't know before you walked in? Good,
Very helpful.
good. I'm glad you're here. I mean, it's this big mystery. Don't let it be a mystery. It's a really important document. You know, that first page, great conversation with buyers and sellers. Second 2 pages, the requirements page. That is, if you're driving, you're closing, you've got to have a conversation with escrow about those requirements. So that you're all on the same page. What piece of paper is going to be needed to clear this issue? And then when you're working with buyers, making sure they're seeing those exceptions, getting copies of whatever easements and CCNRs and whatever else that they might need to know about the property. It's a really important document, and I'm sorry it just gets, just tossed aside because it's giving you everything you can know about your property.
Yeah,
And you
feel
guys
free
are
to,
experts.
request, the vesting deed, that's the deed where your buyer bought the property, you request that, request the tax receipt, make sure the taxes are paid, request the plat, request the CCNRs, that way you guys have that as a marketing tool too to your buyer, be like, hey, this is what you can do with your property, this is how much your taxes were this year, that way they can maybe get an estimate of what it will cost. If you do go to county websites, the mill rate for each assessor is usually listed, so you can kind of get an idea of what the taxes will be for any given year, But I will say Greene County, they're sending out those assessor, mailings out every year now. Our assessments are going up.
Yeah.
It's like crazy. It's like I went 15 years without getting a letter, and then the last 5 I've gotten one every year.
Figure out they can make a little more money if they try.
Yeah. Well, and the COVID stuff kind of
Yeah.
ramped up stuff as well.
Any other questions, you guys? Gonna keep, respect your time.
Thank you, Mike.
Yeah, thank you.
Yeah, thank you for having us over here.
Thank you. Cool.